Hello and welcome to a brief overview of Bulletin 137. There are three interesting cases that are digested in the Bulletin. The first is re Sheehan, which involves an informal will, a will that was signed except in a schedule and also on a page of the will. Interestingly, the execution was videoed, so the court had a complete understanding of what transpired during the sign-up. The judge made a couple of interesting comments, and one that I think is always worth repeating because it has been said before and it just gives added emphasis to it. It says that where he said that, this is Justice Burns, that where there is non-compliance with the formal requirements for execution of a will, there is no presumption of testamentary capacity. So that's an issue that always needs to be addressed where you're seeking a probate of a will that has not been formally or properly executed. In this case, he had the video evidence. He said it was extremely compelling that the person had capacity and the document they signed was intended to be their will, so grant of probate was issued. The next is a family provision claim where it's called Raswold and Court, where a daughter moved in with her father, excluded really visits and later alleged estrangement of her siblings, but the applicant in particular, who stayed away because, or mostly stayed away to avoid any disputes and family discord, but she had moved in to look after her father. He, no doubt at her request, moved $100,000 into an account for her, left her the house and the balance of his estate, which was then $20,000, equally to the daughter's two siblings. The applicant, the son, had allegedly been a drug addict, said he'd been free of drug use for 3 years, but suffered depression. He had basically $11,000 left. He'd had a home in 2019, which he'd sold for $450,000 to clear debts and so on, and therefore he was in very, very poor circumstances. The judge didn't accept that there was an estrangement, as had been alleged, and ultimately gave him $500,000 plus costs. I might say that the house that had been left to the daughter was worth $1.4 million. The most interesting remark made by the judge in that case, I think, was this. While the community didn't ordinarily expect parents to provide their children with an unencumbered house, and by the way, the $500,000 was intended to be sufficient to buy a house of the type that he had before he had to sell it, and give him a little more to clear some debts and basically have a bit of a buffer there. So not expected to do that, but she noted that an adult child's lack of reserves to meet the demands of advancing years, coupled with an inability to earn an income, may give rise to increased call on a parent's estate. So thus he got the $500,000 for those purposes. The final case is a case of Boyd and Talbot, and there an application was made either for construction of the will regarding a charitable trust to be set up, or directions and advice under Section 96 of the Trusts Act. Basically, a trust for 30% of the estate for charitable purposes was to be set up, and the beneficiaries were all to have a role. What was clear was past disputes and anticipated ongoing disputes would make the engagement of all of the beneficiaries impossible from a practical point of view. And in the event, the judge said that the imposition of a scheme under Section 106 of the Trusts Act was the appropriate way to go, not advice under 96, and certainly construction didn't really get there. So as a result, two charitable funds were proposed to be established, and obviously the beneficiaries who clearly could get on or were expected to get on in each group of beneficiaries were put in charge or would be put in charge of those charities. Just an interesting way that a practical problem was resolved by the court, and so that they weren't forced under the terms of the will, so to speak, to cooperate with one charitable foundation, divided it in half, and thus hopefully harmony being secured as a result. So good reading, and thank you again for being subscribers to this bulletin.